we're not saying again that we are granted relief under this. We're just providing them a way which in their jurisdiction, if they wish, they can save face and say, well, under Rule 60, bitch, we know it's not under Rule 60. We know it's because this is the right thing to do, okay? And you know you don't have any authority. So, but whatever, right? So Rule 60 says release from order of judgment. This talks about corrections based on mistakes. This is not a mistake, okay? This is grounds for relief from final judgment, order, or proceeding. So that's the one that we're referencing, 60B. And although I didn't necessarily narrow it down to any one of these in 60B, but most people could see that we can just call it a mistake. I don't know if it's an excusable neglect, but it's okay. We could call it a mistake. You made a mistake. You told me I couldn't access to my kids, but at least you gave them to their daddy. So, you know, we maybe could go with mistake. I don't care which one they choose. I'm just going over what's here. Newly discovered as evidence. Oh, we newly discovered that the mama nor the papa is a foster. Amazing. Nor are they an agent of the state that could have signed up their own family to be fostered in the event that they became disabled or for death. Because that's the other option, okay, guys? The whole Department of Health and Human Services, under which CPS exists, is for the purpose and began for of the purpose, and they tell you right on the dhs.gov website /history that it was for merchant seamen who were injured or killed while they were engaged in their interstate and foreign commerce way back in the 1700s. Okay, that's why it was made. So you can be an agent officer who signed up that in the event you became injured or died, the state is going to implement the foster care program for your children. The other side is you yourself has to be one of those licensees that want to take care of the military foster kids. Okay, that's literally what it says. So if they want to say it's newly discovered evidence that you're neither a licensee or a merchant seaman that has been injured or dead, of course, I know a lot of people love this part, the fraud, misrepresentation, misconduct by an opposing party, aka a violation of their Rule 11 by the attorneys, which requires them to do a due process determination of facts prior to putting their autograph on any complaint, claim, whatever you want to call it, petition, order, anything, notice. They have a responsibility according to their own Rule 11 that says by signing, you're saying you investigated the facts. So if they would have investigated the facts because they did sign, would they not have noticed that the one of the parties doesn't qualify because they don't have any evidence of them being injured or dead merchant seaman, or a foster parent volunteering to take care of those types of children, that class of child. So of course, the judgment is void. We don't have to get into why, but the judgment is void, which is number 4. Again, I didn't specify any one of these. Another one is that the judgment has been satisfied. And then my favorite, any other reason that justifies relief.
Malika, I already sent a void judgment out to everyone, like 70 of them.
Don't matter. Don't matter. It don't matter. This lady confesses. I've not looked at the case. I've not seen anything. I can't make any decisions right now, but I can tell you it's all quasi. So they can pick whichever one of these floats their boat, lights their fancy. Okay, they can take whichever one or none. You know, but 6 is my favorite. Any reason, I don't care. I don't care what reason. You don't want to admit fault. That's fine. Any other reason.